Day 108 since the March 2 general and regional elections, and no declaration as yet. Now, the latest development is that the Court of Appeal will on Friday hear a motion filed to block the declaration of the results of the elections as determined by the recount. The Guyana Elections Commission today put off a scheduled meeting to decide on the declaration of the results after two afternoon AFC commissioners failed to show for that meeting. In any case, there was no election results report for them to consider, as the Chief Elections Officer, Keith Lowenfield, has not submitted his report. He opted to do so after receiving the notice of motion that court proceedings had been filed. Joining me in studio this evening are two learned men of law, the former Attorney General, Mr. Anil Nandlall, and the former Speaker of the National Assembly, Mr. Ramkarran. Gentlemen, thank you very much for taking time out.
You're most welcome.
Thank you. For our viewers tonight, just give us, Mr. Ramkarran, I could probably start with you. Put into perspective what transpired today at GCOM that would have led now to a further extension of this election process.
From what I understand, GCOM had a meeting fixed today for 2 o'clock. The CEO, Mr. Keith Lowenfield, had been required to submit his report.
Right.
And we expected that the GCOM would consider that report at its meeting at 2 o'clock. By about midday, this action was filed by a lady by the name of David for certain orders from the Court of Appeal in relation to the elections and the process of the elections. Now, under the Constitution, certain matters relating to elections go directly to the Court of Appeal. The Court of Appeal decides, and there is no appeal from that decision. So that is what we have. Very peculiarly, they're asking for an order that the CEO failed the GCOM failed to act in accordance with the recount order and amended order by failing to determine the final credible count on the credibility of the results. Well, we haven't reached that stage as yet. So they want a declaration, an order that GCOM failed, a court order that GCOM failed. They want an interpretation of what more votes are cast mean in relation to Articles 177, and so on, some details. But importantly, they have no order to stop the process, no order to halt the process, what is popularly referred to as an injunction.
Right.
And there was no reason, therefore, for GCOM to halt its business, to stop its business. So GCOM could have proceeded at 2 o'clock with the meeting and make the declaration. The chairman makes a declaration. I understand from the news that the CEO did not produce the report that he was required to produce. The speculation is that he received the court order and decided not to. Well, he has no authority or power to do so. Right. And GCOM would have been would have adopted a correct position if, in the absence of his report, they had proceeded to make the declaration. So that's where we are today, and the case is fixed for tomorrow.
Mr. Nandlall, your thoughts on what transpired today?
Well, what transpired today, Avenash, cannot be viewed in isolation. One must look at the larger picture. APNU AFC, from a long time now, have been trying to thwart the electoral process, compromise it, pervert it. They did so from the inception with the installation of a chairman in violation of the Constitution. That chairman went on a house-to-house registration process that the court declared to be illegal. The whole purpose of that exercise was to remove from the list of electors tens of thousands of qualified Guyanese who were qualified to vote and to deny them their rights to vote. Then they failed in that bid as well. Then, of course, when we got closer to the elections, they tried to, during the claims and objection period, for example, they claimed tens of thousands of people were dead and they wanted their names removed from the list. We had to go to hearings and we restored those people's names back on the list. Maracaba is one example. Then even at the last moments before the election day itself, they attempted to deny PPP constituencies or strongholds sufficient number of polling places. And you know, we had a big struggle and we had to overcome that. We eventually did. Then we went to the polls. They clearly lost the polls. They lost the election. When they realized that they lost the election, they tried to use Mingo to contaminate the election for results by the perpetration of a massive fraud. We were able to detect that and countermand that and rescind that by going to court, etc. You know the history. Then they were dragged to a recount. They didn't willingly agree to a recount. They were dragged to a recount. They went there, they tried to stop the recount. Using a lady by the name of Yulita Moore, they went to the court and they tried to stop the recount, though their president had agreed at the level of CARICOM to have a recount. Then throughout the exercise, the recount exercise, they did a whole host of things designed to stall, to undermine the process, making wild, reckless allegations about dead people voting, migrant people voting, etc. Then that they did not succeed again. The results were eventually tabulated, and they confirmed that the PPP won the elections in accordance with the statements of poll that the PPP made public. Then we got to this stage now, the results. They got Lowenfield, and Lowenfield has demonstrated beyond a shadow of doubt that he is part of the rigging cabal, that he is part and parcel of this conspiracy to deny the will of the electorate and to rig the elections. So they got Lowenfield, who is required under the law, to tabulate the results. Lowenfield did so and tabulated the results accurately and presented it to the commission at the last meeting. However, Lowenfield proceeded to do something else. Lowenfield converted himself into a court, heard all what he calls the allegations. He found them to have been proven, and he acted upon them by adjusting the total votes received by the PPP, at least, adjusting it by tens of thousands, deducting those votes from the PPP, and therefore has a bundle of documents that show that APNU won the elections. The chairperson at the last meeting had to make certain pronouncements, and the pronouncements were to the effect that GCOM has no authority to hear and determine allegations that concern or touch the credibility of elections, that allegations of phantom and dead people voting have to be dealt with by an elections petition and heard by the High Court, that GCOM must count only the valid votes, which are the votes that have been counted at the recount. Use those numbers and declare a result. Having made those pronouncements and therefore clearing the way for Lowenfield to go and use the proper numbers, because he tabulated them before and brought them to GCOM. And that is what he was instructed to do at the last meeting. Go and tabulate the results using the real numbers and come back here, because as you know, under the Constitution, Article 177 says that the presidential candidate of the list that receives the highest number of votes is deemed to be elected the president. So at the moment, Lowenfield at the last meeting presented the total number of tabulated votes, and it shows that the PAP won. Irfan Ali is deemed to be the president. So all that he was instructed to do now, in essence, was to go and do the rest of the tabulation, which is the allocation of seats under the relevant provisions of the law. And that is what he was required to do and bring at this meeting. And then at this meeting now, Lowenfield, my learned senior said that he turned up at the meeting. He didn't. Lowenfield was served with these proceedings, and he convinced himself or persuaded himself or advised himself that he is injuncted. No injunction has been granted. And that
so he could have gone ahead.
Yes, he could. He did not even attend the meeting. Again, establishing to the world that he is a willing participant in this grand fraudulent design. Now, so as Comrade Ralph explained, the meeting did not proceed because Lowenfield did not turn up. Lowenfield advised himself that an injunction was granted. The PRO of GCOM issues a statement and says that injunctions were granted, preventing Lowenfield from presenting the report. Although it was explained at the commission meeting that no injunctions were granted, yet Yolande Ward barefacedly publishes a statement to say injunctions were granted, to pave the way for Lowenfield to absent himself and to justify or to corroborate Lowenfield's story. So it's one big design coming from the Secretariat, something that we have been speaking about from the beginning of this exercise. Now the court action. We received, the commissioners receive a notification from the chairperson that the proceedings have been fixed for hearing tomorrow at the Court of Appeal, and as a result that the proposed meeting for tomorrow at 1:30 will not continue, will not take place. We, in the PPP, we have received notification from the court that we are joined in the proceedings and that we must attend court 1:30, and we must put certain submissions in and so on. But I want to speak a little on the court matter itself, if I may be permitted to do so. As Comrade Ralph correctly said, the Court of Appeal does grant us very unique and special jurisdiction to allow a narrow compass of matters to be heard at that level of the judiciary alone. Now, because it's a matter that will only be heard in the Court of Appeal, and you can go no longer, obviously, that is a jurisdiction that is sui generis, or very special, and therefore, when it is invoked, the rules governing its invocation must be strictly complied with, and whatever matters are to be ventilated in that court must be strictly and scrupulously comply with the parameters of the court's jurisdiction in that respect. What you have here is a disguised elections petition. What the framers of this document wanted to do is to commit a judicial coup, to use the judiciary rather, to commit a coup, because they don't want to go to the court by way of an elections petition, which is the required thing to do. An election petition requires first the declaration of the results,
Right.
and that would mean that the government will be installed and a new government appointed. And then you go to court to challenge the results. That's what the law says. And you do so in the High Court. They don't want that to happen. They don't want to follow that required procedural legal pathway. They want to circumvent that because they want to stay in the government. So they wrongly invoke this special process in the Court of Appeal, and what they are seeking here are reliefs that can only be claimed on an elections petition. So they want a declaration that the results, that the GCOM has failed to determine the final credible results. They want an order restraining Lowenfield from carrying out some. These are matters, when you examine them and you distill them, they all concatenate to question the validity of the election process. And the law says that those issues must go and be heard by an election petition. They want to dress it up now, disguise it, to make it look like a matter to be determined in the Court of Appeal. And the court ought not to allow that. No court, worth its salt, should allow its process to be abused. Now, Article 177 of the Constitution, and that is the article that they have invoked, that's where you can go to the Court of Appeal. It only allows you to question the qualification of the president. Only the qualification of the president or an interpretation of the Constitution. Now, so first of all, by invoking that process, they are obviously assuming or admitting that Irfan is the president.
Right.
Because they're going now to that's what they said in the paper. They're questioning Article 177.4. That's what they say here.
Right.
Article 177.4, let me read it quickly for your viewers. The Court of Appeal shall have exclusive jurisdiction to hear and determine any question as to the validity of an election of a president, insofar as that question depends upon qualification of any person for the elections. So you can only question Irfan Ali's qualification. So if you're going to question that, it means that you have assumed that he's the president. But nowhere in this paper, nowhere in these proceedings, is there any question about Irfan Ali's qualification. None at all. Now it also says, and or any question or the interpretation of this constitution. Now that phrase there must be read narrowly. It can be any interpretation of any provision of the Constitution, because the High Court has a power to interpret every provision of the Constitution. Right. It must mean an interpretation of the Constitution in relation to the qualifications of the President, because the qualification of the President remains the kernel of this section. Remember, the framers of this Constitution was very careful. Remember, a person is already elected president, and now you want to question that person or stop him from being sworn in. That's what all of this is intended to do. The law doesn't give you a carte blanche. The law narrows the scope of your challenge and reduces it only to questions of the presidency, questions of the qualifications, and that's exactly what it says. So, and this here, when you read it, it has nothing to do with qualification of the president. One, a declaration that the Guyana Elections Commission failed to act in terms of some order 60 of 2020. I mean, what that has to do with Article 177? Secondly, an order restraining the election officer from complying with the direction of the chairman. How that fits into this? And thirdly, an order restraining the election officer from complying with the direction of the chairman again. And an order restraining the election officer from submitting to the Guyana Elections Commission the election report which is required to do. What that have to do with this? You understand what they have done?
Yeah.
They have simply filed a set of papers, write any set of foolishness on it, and wants to invoke the special provisions of this article. So this thing here is completely without merit. It has no basis whatsoever. And it should be, in my humble view, be dismissed very summarily by a court with a heavy imposition, or rather an imposition of a heavy order for costs. Right? I will pause here for Mr. Ramkarran to make his contribution.
You want to go ahead or let me?
Well, going back to Article 177.4, if I may read another portion of it that Anil did not quite get to. The Court of Appeals shall have exclusive jurisdiction to hear and determine any question as to the validity of an election of a president. I don't think Anil stressed that. The validity of an election of a president, that means that the election had to have taken place.
Right.
The election process is not yet completed. The election includes a declaration, the process includes a declaration by GCOM and the swearing in of the president. So there is no completed election in Guyana. And it deals with the qualification of the person. Is he a Guyanese? Does he have the required age? Does he have a criminal conviction? All of these things relate to the qualification of the president. As Anil has pointed out, there's nothing in the papers relating to the qualification of the president or of the interpretation of the Constitution in relation to those matters. Now, it is very difficult to conceive that the Court of Appeal will require the respondents in this matter, that is to say the Elections Commission, the Chief Election Officer and so on, to answer, to respond. You know, in the old days, the courts would hear you and then they tell the other side, we don't wish to hear you. That doesn't happen often now. But this is a matter in which the Court of Appeal requires no answer from the respondents because no case has been made out. And this seemed to be an attempt to unlawfully stop the process of the elections. You know, the CARICOM team have considered some of these things. And they said that this is a fishing expedition that went on at the recount process. The recount process, which is really an audit, which I wrote about several weeks ago, and said that the recount has been hijacked and converted into an audit. They probably read my article and agreed with that this is an audit, and it was designed to prolong the process. And they said that APNU AFC was on a fishing expedition to see what they can catch, and all they got are very slim pickings. And they concluded that, of course, the elections were credible, and that if any party wishes to challenge the results, they must bring an election petition. And this is what they have done, just to obstruct the process.
And that is why I give you that long introduction, because I want to situate this as another obstacle that they are erecting in their efforts to thwart democracy and to defeat the will of the electorate. That is all this is. But it cannot succeed. It cannot succeed because it doesn't fit within the four corners. You know, just because the Constitution says, apart from the qualification of the President or the interpretation of this Constitution, you know what they're asking? So they found three words, and they want the Constitution, they want the court to interpret it, because so that to fit it to satisfy this requirement. And this is what the words that they want to ask the court to interpret. An order that there be an interpretation of the words, quote, more votes are cast, in Article 177. Now, I can ask your cameraman there, that young man, and he will tell me what more votes are cast mean. This is not Latin. This is not law. This is ordinary English language expressed in its most unambiguous fashion. These are grammatical words. You want to ask an entire court of appeal to interpret what the word more votes are cast means? That's what they are. But this was simply to fit it into this article here. These people are insultive not only to the Guyanese electorate and the Guyanese public, but they are highly insultive to our courts, because this is what judges got to come out and listen to. And I hope tomorrow that the judges deal with them condignly and in a manner that they should be dealt with.
As I mentioned initially, we're over 100 days since voters went to the polls. At the start of the day, of course, Guyanese were optimistic that we would have a declaration today. Did you guys, as legal minds, envisage something like this would have happened by the end of today? And two-part question, your anticipation of what will take place tomorrow or could happen tomorrow?
I am sure that my friend, my learned senior counsel will agree with me that lawyers can only predict what is rationally predictable. Of course, reality brings with it irrationality. No one, no lawyer, I don't care how experienced he is and how skillful he is, would have anticipated a ridiculous stunt like this. This is, I thought that they would have gone to the High Court and tried to get an order blocking Lowenfield. I mean, that was what the rational mind could have predicted or conceived.
And something you could have anticipated for.
Yes, but to go to the Court of Appeal, where you have no appeal, to invoke that provision of the court, which I don't think has been invoked ever in this country.
No, never.
Ever.
That is historic.
Ever in this country, by a lawyer named, and I don't like to get personal, but I got to mention it, by a lawyer named Mayo Robertson. You ever hear about a lawyer named Mayo Robertson?
During this election.
Huh? Only during this election. Yeah. But nobody knows him because he has no practice in this country.
I know him very well. He was he was around practiced here in the 70s. He was working with Clark and Martin, and we were friends at that time. And friends today.
But he left and he went somewhere.
He left, migrated to the United States in the late 70s.
So you agree with those sentiments about...
I agree with the sentiments, but I think it needs to be stressed for the public to understand that the recount order is being challenged. And what is being put on the table is Lowenfield's interpretation of his functions under that order. The recount order provides for him to have matrices of the recount process in each region. In other words,
The totals.
the totals. Just put them on one sheet and so that they can be easily understood. He is required to do that. It's a mechanical process. It's not an interpretation process. He puts the figures on a sheet. And then to prepare a summary of the observation reports. A summary, not to give his opinion on the observation report, just to prepare a summary. What they are asking for in this case, without actually saying so, is they want Lowenfield's interpretation, his ultra-vires, completely unlawful opinions given on the observation reports that the election, the figures are not credible. And he gave his own figures, 250,000 around that or of the votes cast are not credible.
275.
275, and only 180,000 are valid. Where he got those figures from, no one knows. And this action is seeking to put that interpretation in play, and for the credible to be interpreted on the basis of the figures and the opinions given by Lowenfield, which have been totally and completely rejected by the CARICOM team, which President Hoyt has said that he has confidence in.
Granger.
President Granger, repeatedly. Repeatedly he said in his interview at the convention center, he said repeatedly that he has confidence in this
And
team.
they are the most legitimate interlocutors, and that their report must be taken into account by GCOM. But in addition to what Ralph said, the chairperson herself, at not today's meeting, the meeting before, 2 days ago, adjudicated, so to speak, or dealt with Lowenfield's figures and rejected them out of hand, because Lowenfield sought to disenfranchise 275,000 Guyanese electors on the basis of untested false allegations made by one contesting party, without affording these people, any of the voter or their political party, a right to be heard, an opportunity to test the allegation made, an opportunity to lead evidence of their own, an opportunity to be present with their lawyers, all are which rights that they are entitled to before they can lose their votes. But Lowenfield, with one swipe, APNU asked for 250,000 votes to be annulled. Lowenfield gave them more. He gave them 275,000. So willing he is to please his political masters. And I want to reiterate here that I was reading some cases. Fraud at common law, electoral fraud at common law, is what Mr. Lowenfield is toying with. The cases say that if you deny or defeat or fraudulently take away the vote of one voter, you are destroying a democratic process. If you deny the votes of dozens, you can make a wrong person elected or make a wrong government go into power. This banner denied 275,000. And in those cases where persons did it for one vote, a person pretending to vote when he was not qualified to vote, those people get 4 and 5 years imprisonment. Multiply that by 275,000. And the offense doesn't carry any limit in penalty. You can get as high as life imprisonment. And a lot of people don't want to talk about this also. Let me talk about it too. What they are interfering with here is a government taking office, an elected government. The results of this election were counted at the polling stations, counted by all the polling agents and everybody, UPNU agents and everything, recounted nationally, broadcast on the air, tabulated on live television every afternoon, and the results totaled by the same corrupt low and feel. And you have it. So nobody is in doubt. So you know that a government has been elected. What we are engaging now is a formality of the process, solemnization of the process, getting the man sworn in, etc. As I said under the Constitution, he's already elected. What they are doing is subverting a lawfully elected government. Subverting a lawfully elected government is a capital offense in this country. A capital offense.
I don't know if you guys could shed some light on today. You hadn't a quorum because 2 of the commissioners were not present. How is this fix going forward if we have a situation where commissioners don't turn up and you don't have a quorum in the immediate and upcoming meetings?
There's a process in which you, there's a process in the Constitution, I believe, in which you, if one side doesn't turn up, that you go through a process and a quorum is eventually arrived at with the 3 commissioners, and the chair. You adjourn the meeting for 24 hours and give a further notice and so on.
But I want to make the point that these things are not happening by coincidence. These issues or these steps or these manifestations that you're seeing here are all one orchestrated design. Lowenfield not turning up because he claims that he was served with an order, and then the other commissioners suddenly not turning up at the same time. But as Ralph said, the Constitution has a mechanism. The law, the arms of the law are very long, but in the end, the law will prevail.
All right, gentlemen, we are running out of time. How close are we to a final declaration of the results? Because it's been going on over 100 days now. In your estimation, how soon could we have a declaration?
Well, this case should take not more than a week. And
not more than a week, so you're talking next...
We're talking 1 week
Thursday?
from now.
1
1 week and 2 days to get the process completed.